I'm going to talk about China's maritime militia and international law implications. So the maritime militia is an auxiliary force composed primarily of fishing vessel cooperatives that work in conjunction with the People's Liberation Army, Navy, and other Chinese government departments in order to advance or further the interests of China. So this is a group that has economic motives to fish, but also has an auxiliary function. And all of law consists of two different types of bodies. You first have evidence or information or facts, and then you have the actual legal doctrine. And so first what I'll cover are the facts, and these facts are derived from the China Maritime Studies Institute research on the Chinese maritime militia, which is done at the Naval War College. And what they have done is looked at original Chinese language government sources to derive this information. And so all of my facts are taken from the good work of the people at CMSI. The maritime militia is best sort of represented by this Hainan Provincial Fishing Industry website, which says casting government fish and casting nets of sovereignty. So the maritime militia is very much intertwined with the Chinese government and is an instrument of the government. It gets political support from Beijing. It also receives investment in infrastructure and expansion, including a massive expansion in Chinese fishing vessel capacity, which is ironic since we know that the South China Sea is actually overfished and there's overcapacity, not just in China, which has the world's largest fishing fleet of 200,000 vessels, but also in some of the other countries. But this is in order to support this auxiliary function or this secondary function. They also are entitled to fuel subsidies, extensive paramilitary training. They are eligible for pensions if they're injured in the line of duty for these auxiliary or militia functions. They're provided satellite communications and other methods to be able to command and control this force as a government instrumentality. And all of this is part of an asymmetric lawfare or asymmetric tool of the government in order to occupy and dominate the so-called gray zone, or this area that's uncomfortably lying between peace and war. During wartime, the militia can conduct a number of different functions or missions, including intelligence, surveillance, and reconnaissance, concealment, harassment, blockade, envelopment, and mine sweeping, transportation, island defense, and patrols. And the militia is not a new event. In fact, after World War II, it was used primarily to counter nationalist infiltration of the mainland. And then in 1974, it was instrumental in the Battle of the Paracel Islands, in seizing the Paracel Islands from Vietnam. And this battle has now been mythologized as the first sort of successful naval battle, and also the first successful major operation of this combined civil and military force to achieve the aims of the state. Right now, we're witnessing the maritime militia involved in a number of peacetime roles, including at the core of the so-called cabbage strategy or gray zone dominance, also critical infrastructure protection such as ports and oil rigs, and certainly rights protection missions or missions to vindicate or advance the claimed rights of China, primarily based upon historic rights, harassment of foreign vessels that are both warships as well as civilian vessels. Again, ISR, including this incident here where a fishing vessel was able to net some country's unmanned underwater vehicle and then deliver it to Chinese authorities. There's also now growing suspicion that the maritime militia may be involved in interference with submarine cables, as well as, of course, what we're most familiar with, which is its role in power projection. I'll focus on just one of these cooperatives, which is the Sanye Fugan Fisheries Company, and it was founded in 2001, and it's quickly grown since then. It launched in 2011 a 3,000-ton fisheries supply and command and control ship that it's used or operated in conjunction with fisheries vessels to project power and to harass foreign ships. So in 2010, for example, this large command and control ship led a flotilla of 29 vessels around a number of the features in the vicinity of the Spratly Islands, including Fiery Cross Reef, Subi Reef, Mischief Reef, and operating in formation steaming and with command and control from the large ship. And then upon their return, they went through recognition ceremonies, arrival ceremonies, citations for bravery on behalf of the state. This is the same group, by the way, that was involved in the HYSY 981 cabbage tactics or cabbage strategy to protect that critical asset that was placed in the disputed waters and that was involved with Vietnam, drove away a number of Vietnamese vessels that were protesting the arrival of this oil rig in Vietnam's exclusive economic zone. And this is also the group that was involved in two other incidents, the Bin Min 2 and the Viking 2 in 2011. It's going on even today. Just about a month ago, Vietnam seized a vessel that was disguised as a fishing boat, but in fact was a tanker with 100,000 liters of diesel fuel on board that was being used to illicitly supply fuel to fishing vessels that were operating in Vietnam's exclusive economic zone. The Philippines has also been subject to this same fishing cooperative maritime militia tactics, specifically and most recently in 2nd Thomas Shoal in 2014, when the 8161, the 3,000-ton command and control ship, led 7 large Fugang trawlers to try to intercept the resupply of the BRP Sierra Madre, which is this derelict former U.S. warship that the Philippines has grounded on the reefs there at 2nd Thomas Shoal in order to sort of resist Chinese encroachment. Also, just a month ago or 6 weeks ago or so, Malaysia experienced what appears to be maritime militia when 100 Chinese fishing vessels were operating around South Luconia Shoals offshore of Sarawak, that far south, and the Malaysia Maritime Enforcement Agency and the Royal Malaysian Navy encountered all of these fishing vessels that had no flags and no apparent registration, 100 vessels, and yet they were operating in conjunction with 2 Chinese Coast Guard ships. Indonesia as well, again about 6 weeks ago, Indonesia was involved with this incident, the Kuifei 10078 and 8 crew that were arrested for illegal fishing in the Natuna Islands, EEZ, and the vessel tow line was cut by a Chinese Coast Guard vessel. Indonesia, the Ministry of Maritime Affairs and Fisheries has had several incidents where where its operations against illegal Chinese fishing have been disrupted by Chinese Coast Guard ships, including ships that these fisheries law enforcement vessels 310 and 311 that have actually pointed weapons at the Indonesian vessels. And it's interesting that these 2 ships, 310 and 311, continue to sort of crop up in incidents. In this one incident in March of 2013, the fisheries law enforcement vessel 310 demanded the release of captured fishermen that had been fishing illegally, and in that instance it used sirens and bridge-to-bridge communications as well as apparently satellite communications jamming equipment to prevent the Indonesian forces from contacting their headquarters. And in that incident, as well as in all the incidents actually, Indonesia backed down until this most recent one in 2016. So that adds a new sort of cyber warfare wrinkle to the maritime militia, that apparently they're capable in some instances of operating in tandem with the Coast Guard and preventing communications between other forces and their national leaders. It's not just the South China Sea, but it's also in the East China Sea. Korea has encountered Chinese fishing vessels and maritime militia. In this case, you can see here in the photograph, the Chinese vessels have lashed all of their ships together in order to impede boarding by the Republic of Korea Coast Guard. Japan has faced similar challenges around the waters of the Senkaku Islands. And of course, the United States on a number of occasions has encountered vessels which have confirmed ties to the maritime militia, particularly this trawler 8399 that you see here that was involved in the USNS Impeccable incident. That was the 2009 incident when the USNS Impeccable, which is a U.S. Navy auxiliary warship, was conducting military surveys in the Chinese exclusive economic zone, and it was surrounded by government vessels as well as trawlers that have been linked as members of the maritime militia in an effort to try to impede those military activities. So with that, I'll turn now toward the legal implications. And with the legal implications, it's important to keep in mind that there's two bodies of law that would apply. There's a law of naval warfare that would apply during periods of armed conflict, and then there's the peacetime law of the sea, or the United Nations Convention on the Law of the Sea, which sort of serves as the constitution for the world's oceans. And under that peacetime regime, vessels may be flagged in any state, but whatever state carries that flag, the state has a duty of implementing internationally accepted standards. And so what I would argue or suggest is that the maritime militia in practice so far has not complied with these internationally accepted standards. So in peacetime, it's important to remember that in the UN Convention on the Law of the Sea, the flag state has important rights as well as corresponding duties. So the flag state has a right to register vessels and have those vessels fly its flag, and then those ships are free to use the global commons and travel throughout the world. But flag states also have corresponding duties, which sometimes are not as strongly observed. We see this in the phenomenon of open registries or flag states of convenience, but it also appears to be a feature of the maritime militia, where the flag state has failed to exercise effective jurisdiction or effective and exclusive control over the maritime militia, and has not observed international rules, and it has failed to investigate incidents or cooperate with other states to find out what has occurred in incidents, and it has also failed to monitor administrative, technical, and social matters and make sure that the crew are trained and operate in accordance with international standards. Well, what standards are we talking about? In particular, there's the collision regulations, or the International Convention for Collision Regulations, and I've highlighted just a couple of them here. As I talk about it, you can see that this is a Chinese maritime militia cargo ship that's bearing down and actually sank a Vietnamese fishing vessel. But the collision regulations have a number of internationally accepted standards, and those standards apply both to warships as well as merchant vessels. And they include rules 6, 7, and 8, which I've highlighted here, which is the obligation or the duty to maintain a safe speed. Rule 7 is the duty to avert any sort of risk of collision, that is, to take affirmative steps to avoid collision. And then Rule 8 is even stronger language, which is that every possible means must be taken to avoid a collision. Here you see apparently just the opposite of that, where a maritime militia vessel actually sank a Vietnamese fishing vessel. There is some suggestion that the maritime militia may be involved in submarine cable cutting. There's less direct evidence, but I think that more will come to light. In any event, submarine cables are responsible for about 95% of global telecommunications, and of course everything that we do from banking to communications is linked to submarine cables. It all goes under the water rather than through satellite, because satellite is still far too expensive and the bandwidth is limited. China is by far the global leader in what are called politely cable faults, which are broken submarine cables, and the principal responsibility lies with Chinese fishing vessels. So there may be instances, particularly in cases of inadvertent dragged anchor, where it might be inadvertent, although it also could be a purposeful campaign. In any event, it is somewhat telling that there's not been a single civil case against a Chinese fishing vessel for a broken submarine cable, even though they are the principal agent for those incidents. If so, this would be inconsistent with a long-standing and multidimensional regime or legal set of rules for submarine cables going back to 1884, which says that all vessels should stand clear of areas of submarine cables, including of vessels that are repairing or that are maintaining submarine cables. So the vessels that are maintaining and repairing submarine cables actually have a right of way under the collision regulations and the UN Convention on the Law of the Sea and other multilateral conventions. And those rules do not appear to have been observed in several instances that involve maritime militia. In the few minutes remaining, I'll also talk about the law of naval warfare, and this is that body of law that applies during periods of armed conflict. The problem that the militia pose is that it violates one of the core fundamental principles of the law of armed conflict, also known as international humanitarian law, and that is that humanitarian law is designed to protect civilians and civilian objects, such as regular workers, schools, hospitals, and also fishing vessels. So this is the principle of distinction. That is, that states have a duty to make these civilian objects distinct and separate from its armed forces. And that's exactly the opposite of what a maritime militia does, which tends to blur or merge these civilian forces into the armed forces. What this does is it exploits a gap in international law between peace and war. And this gap was really exposed in the U.S. v. Nicaragua case at the International Court of Justice that my dear colleague Nong mentioned in her presentation. And that is that under the UN Charter, states have a right of self-defense if they are subject to an armed attack, or in the equally valid French translation, armed aggression. So if a state commits armed aggression, which is forbidden and crosses the line of this Article 2, Paragraph 4 of the UN Charter, a state at some point thereafter enjoys the right of self-defense. But what the Nicaragua case said is that it's not a bright line. In fact, the U.S. lost that case because the U.S. claimed that once this line is crossed and that a state is subject to an armed attack, that immediately triggers this right of self-defense. The court disagreed and said, no, there's actually this gap, that even though a country is subject to an armed attack, it may not exercise the right of self-defense if that armed attack does not reach a sufficient gravity or have sufficient scale and effects of a conventional attack. What this does, in my view and in the view of some scholars, is that it creates this gap which seems to license this low-level asymmetric armed coercion or armed attack. And therefore, it actually is ripe for exploitation by a force such as the maritime militia that comfortably operates and dominates inside this gap, achieving its ends while avoiding full-fledged conflict. Thank you very much.